Welcome to the Explainer. Today, we're taking some pretty dense legal doctrines and turning them into a journey about, well, fairness. We're looking at the history of personal injury law, and specifically, what actually happens when an accident isn't just one person's fault. Let's get right into it. Here's our roadmap for today. We'll kick things off with the blame game, look at the all-or-nothing approach of contributory negligence, explore the last clear chance doctrine, and then see how we share blame through comparative fault, both pure and modified systems. Section 1. The blame game, when the victim is also at fault. So picture a highly relatable scenario. An accident happens, but the person who actually got hurt was kind of acting carelessly too. Put yourself in the shoes of a judge or a jury for a second. Ask yourself, should someone who's, say, 1% at fault lose their entire case to someone who's 99% at fault? Imagine a driver texting and blasting through a red light, hitting another car. But that second driver, they were going 1 mile per hour over the speed limit. Technically, they both broke a rule, right? Both were negligent. So how on earth does the law decide who pays? Which brings us to Section 2. All or nothing contributory negligence, the harsh common law approach. Under this traditional rule, contributory negligence, if your conduct falls below a reasonable standard of care and causes your injury, you get nothing. Zip. It absolutely does not matter if the other guy was mostly to blame. It stems from this surprisingly strict old idea that a plaintiff has to come to court with quote-unquote clean hands. Turns out, if you contributed to your own harm, even the tiniest bit, the law just completely bars you from getting any compensation whatsoever. You can really see this in action with the DC case of Massengale v. Pitts. We have an intersection collision where the defendant was clearly negligent, but the plaintiff, Ms. Massengale, even though she had a green light, failed to maintain a proper lookout. And the facts here are wild. She was driving without her required glasses, she was speeding, and, wait for it, she was actually praying with her head bowed while driving. Yeah, probably not the safest time for a prayer, right? And because Washington, D.C. followed pure contributory negligence at the time, her recovery was totally barred. Her own negligence was a substantial factor, so she got absolutely $0. The defendant's negligence basically just vanished into thin air because the plaintiff was also at fault. Section 3. The last clear chance, the chronological Band-Aid. You know, recognizing just how incredibly harsh this all-or-nothing rule was, the legal system eventually came up with a chronological Band-Aid to save negligent plaintiffs. Here's the gist of the last clear chance doctrine. In a contributory negligence system, the last person who was negligent becomes the loser. Think of it like this. If you carelessly put yourself in danger, but the defendant actually sees you, has plenty of time to stop, and just doesn't, the court will ignore your initial mistake. The defendant takes on full liability because they had a real, final opportunity to stop the harm from happening. A great example is Dickerson v. Martin. An 18-year-old pedestrian crosses mid-block at night, totally failing to yield or look out for cars. He's clearly contributory negligent. A driver going 30 miles per hour hits him. Under strict contributory negligence, he'd get absolutely nothing. But the evidence showed that this pedestrian, even though he was wearing dark clothes, was walking at a normal pace right under a bright street lamp. He was actually visible in the street for up to 12 whole seconds before impact. Now listen to the court's wording here. They said the jury had to decide if those 12 seconds gave the driver a chance that was clear and not merely a speculative possibility to swerve or brake. Because the pedestrian was visible for that long, the court let the jury use the last clear chance doctrine, which potentially saved the pedestrian's entire case. All right, Section 4. Sharing blame, comparative fault, the modern equitable approach. Eventually, courts woke up and realized these chronological loopholes just weren't cutting it. They were trying to fix a broken, unfair system with more rigid rules, which brings us to the much better reasoned modern approach. Most jurisdictions today use comparative fault, or comparative negligence. Instead of demanding perfect clean hands or obsessing over who had the absolute final chance to hit the brakes, this system embraces reality, shared blame. It's a way more flexible, common-sense idea designed to divvy up the loss fairly based on exactly how at fault each person actually was. Let's translate this into real math. Imagine a scenario where the jury listens to all the evidence and decides, okay, the plaintiff is 40% responsible for their own injury and the defendant is 60% responsible. If the total damages are $10,000, the math is super straightforward. The plaintiff's award is just reduced by their 40% share of the blame. So they eat $4,000 of the loss themselves, but they still walk away with $6,000 from the defendant.
This makes sense, right? It encourages everybody to act safely because everyone pays for the exact proportion of the damage they caused.
Moving to Section 5, pure versus modified systems. Where do we draw the line? Sharing blame sounds simple enough, but jurisdictions are actually split on how much fault a plaintiff can have before they're kicked out of court entirely. So we have two main frameworks. In a pure comparative fault system, a plaintiff who is 90% at fault can still recover 10% of their damages. But modified comparative fault systems, they hold on to a little bit of that harsh old-school contributory negligence logic. They say, sure, we can share blame, but only up to a certain point. If you're too responsible for your own injuries, we aren't letting you sue someone else. And hitting that specific threshold changes the whole game. In a state using the greater than 50% rule, you could be exactly 50% at fault and still get half your damages. But if a jury says you're 51% at fault, your recovery drops to zero. Boom, nothing. Meanwhile, in a 50% or greater state, being exactly equally at fault, a perfect 50-50 split, means the plaintiff gets $0. That exact threshold was the absolute battleground in the 2012 case of Paul v. County of Furnace. A speeding driver crashes, but the county was also negligent because they didn't maintain a retroreflective warning sign. Since Nebraska follows the 50% or greater approach, the court had to carefully weigh the driver's speeding against the county's missing sign. If the court found the driver even perfectly equal in blame, just hitting that 50% mark, he would lose everything. Stepping back, look at this incredible evolution in legal history. We started with a punishing common law rule where a tiny 1% mistake cost you everything. Then we moved to these complex chronological tests like the last clear chance. And finally, we landed on today's nuanced systems of percentages and shared responsibility. The law is just constantly trying to refine its definition of what is actually fair when humans, inevitably, make mistakes. As we wrap up this explainer, I want to leave you with this to ponder. If we, as a society, accept the logic of comparative fault, that blame can and should be shared mathematically, does drawing a hard line at 50 or 51% actually serve fairness? Or is it just another arbitrary rule, a ghost of the old contributory negligence system still haunting modern courtrooms? Really makes you think. Thanks for exploring this with me today.